morning.
Good morning. Stephanie, are you there?
I am. Can you see me and hear me?
I can see and hear you now.
Not sure what happened.
Yeah, something's wrong with your connection. All right, let's try to get started.
Good morning.
Good morning.
Good morning, Judge.
Morning.
Good
morning.
Do we have Monique Tate sitting in here? No. All right. World Over is going to have to wait. You're third on the docket. I'm just going to mute you for now. Do we know if Miss Tate's going to be joining us for this hearing?
I did talk to her on Friday and I did remind her of the hearing. And she indicated then she was gonna show up, so maybe I'll send her an email and call her to find out if she's still planning to attend.
Yeah, let's find out if she's going to join us because I do not have her in the waiting room.
Okay,
And part of the status hearing is she was going to hire a lawyer. It needs time. And this was supposed to be sufficient time to get her a lawyer, and we're going to get a status of this case and move this case along. Tell you what, let me just put y'all both back in the waiting room, contact her, Miss Rawlins, see if you can get her on Zoom with us, and we can have the status conference today.
okay.
Thank you. Sarah.
Yes,
The
sir.
next case on the docket, Bank of America NA versus William Mallory. I have a Marley Thames and a James Heston listed as attorneys. You can see the waiting room. There is nobody by those names in the waiting room. Would you message the waiting room to find out what's going on, if anybody there is coming in place of one of these two attorneys?
Yes. Judge, they filed a dismissal late yesterday.
Okay. Why don't you send that to my queue?
Okay.
All right, let's move on to the World Over International case.
Are we unmuted?
You are. All right, we're on the record in 22070727 World Over International LLC versus Ansar Oud Dean Society of Nigeria, Melissa Blake Griffin, Blake Willie Elton Estate, Donald Blank, Danielle Richardson, and Daniel Richardson. Let me get announcements from the attorneys present.
Tim Smith for World Over International.
Ryan Marquez for Danielle Richardson and Nathaniel Richardson.
Okay, very good. We're here on a motion for reconsideration, emergency motion for reconsideration, granting the World Over International LLC's partial agreed motion to inspect and survey. I've reviewed the motion, but and I find the argument well reasoned, but I want to hear arguments. Mr. Marquez, it's your motion, so why don't you get us started?
Judge, there's also an additional thing that might resolve the whole case. We also have a plea to the jurisdiction that is on file. And so I don't want to get into the emergency motion unless maybe we first go through the plea to the jurisdiction that was also put on the setting.
When was that filed?
That was filed back in November, Judge. And we kind of did a joint notice for both of them. Like on the docket sheet, I even noticed that it did say for our emergency motion and for.
I'm sorry, Mr. Marquez, you're gonna have to move closer or
Oh,
speak
okay,
louder.
I apologize. Okay, we filed the plea of the jurisdiction back in November, Judge. I believe, and we had done a joint setting for both of this. It was listed in the court website I saw. So I double checked that before I came, and on the court website does note that it's both the plea to the jurisdiction and the emergency motion to reconsider that we filed.
Sarah, I'm not seeing the plea of the jurisdiction filed in the case at all.
It's not filed. When he said this, he said it would be filed. It has not been filed.
I do not have that filed whatsoever, Counselor.
I apologize. I thought we had filed it the same back in. I think I have to check what we had said. It. The problem is, Judge, is well, I guess orally I have to just state that this court doesn't have jurisdiction over title issues because this is a county court at law, and so there is no jurisdiction to hear this. The jurisdiction is tied to whatever the code sets. Only certain counties for civil county courts at law and county courts at law in general have been given jurisdiction to hear title issues. And like Harris County has that jurisdiction, but the Fort Bend has the state legislators never authorized Fort Bend County to hear title disputes.
I agree with that. Now, now I'll take that as part of your emergency motion to reconsider since it's argued in there. I do not have a plea of the jurisdiction in front of me, so I cannot hear that, but we'll consider your emergency motion. Counselor, would you like to respond?
Yes, Your Honor, briefly. I think the most expeditious thing might be to do, because I did receive notice. I mean, I received the motion. I don't know if it was they just served it to me and didn't e-file it, but I did receive the motion. Now, I didn't receive a file stamp copy. So you don't have it, so we can't do it. It seems like we ought to just reset both of them for as short as possible so that they could have their jurisdictional matter heard, because if they're correct and we are arguing about title, then.
Well, hold on, Counselor.
Yes,
I
Your Honor.
just received notice that it's filed under a different title here in the system. Let me find it. Hold on.
Okay, good. Because, Your Honor, it may resolve the issue. That is to say, the case.
Yeah, it was filed in October, not November,
Oh, okay.
Yeah.
I'm sorry, Judge.
and it's filed under a different title, but I have it. I do have it in front of me.
Okay.
Okay, now, plea of the jurisdiction. Mr. Marquez, do you have any further argument other than what you just stated?
No, Judge.
All right, opposing counsel.
Tough for me to rebut that, Judge. We're arguing about an easement and the titles from about 3 different deeds. I don't really see how I get around that.
No, you don't. I agree with the motion. I agree with the plea of the jurisdiction wholeheartedly. I mean, I don't have jurisdiction over this matter.
Your Honor, may I point out that I did not initially file the case, that I just came in on the case. Not that it matters, I should have caught it, but There it is.
Well, do I have an order that I can sign off on just dismissing this case altogether?
I believe so, Judge. Would have to make sure though, if you like, if there's not one, I'll go ahead and prepare one today and send it.
I'm looking through the system. Sarah, do you see an order?
1 second, Judge.
You're not aware whether there's an order in there or not. My only.
There's no order.
Okay, well then my request would be that it be dismissed without prejudice since it's jurisdictional and they're gonna restart it in district court.
I'm making a document granting the plea to the jurisdiction and dismissing the matter. But I'd like an order so it's clean.
Judge, I'll draft and submit it right now. I have my
Thank you
laptop.
very much.
So I'll draft it and submit it right now.
All right. That concludes the hearing. Y'all are free to go. Thank you.
Thank you,
Thank you,
Judge.
Judge.
Let me mute this, guys. Hang on, hang on.
Ms. Tate,
Yes, sir.
do you have an attorney?
No,
You did not retain counsel?
no.
Okay. We're on the record in 21 CCV 069529. Monique Take is next to friend of JT versus Carla Harwell and William Harwell. We were here last in September regarding a status conference. Ms. Tate, you stated to the court that you were going to hire an attorney and need some time. I went ahead and gave you that time and gave Ms. Rawlin some additional time to meet with the child. Ms. Rawlin, have you had a chance to meet with the child?
We visited via Zoom last week. So I did talk to her and I got understanding of her injuries. And also I talked with the mom also.
Okay. And for the record, Ms. Tate, you have not retained counsel. Is that correct? Correct. Excuse me.
Correct.
I'm sorry, what was the answer?
Correct. Correct.
Thank you.
Okay. All right. What are we going to do with this case? I mean, we're now just kind of sitting in limbo. It's been on my docket now for almost 2 years, closing in on it at least. Year and a half for sure. Mr. Jonick?
Yes, Judge.
You are
Counsel for defendant.
counsel for defendant.
If the ad litem is agreeable to and think this is in the best interest of the minor, Judge, I mean, I'm not opposed to setting it for a prove-up hearing for this matter, because like you said, it came to me as a friendly suit that all parties were in agreement with it. And the longer it sits around, the money that could be sitting in the registry of the court earning interest is not doing so, or being, in an annuity wherever. So I think it'd be in the best interest of the child to set it for a prove up.
Ms. Ronwin, how do you feel about that? I know you just met with the child last week, but how do you feel about moving forward?
I feel fine about moving forward, my understanding, and Monique can correct me if I'm wrong, is that she's decided that she does not want to get outside counsel anymore, or her own attorney. She just wants to move forward with it. And we just met on Friday, so we haven't had a chance to I guess make sure everything's in order, but that's what the indication to me is, that she's gonna be ready to move forward. There was one thing that the child said that was a surprise to her about the injuries, that she was gonna be monitoring over the weekend to see if there was any more confirmation of those injuries that are allegedly from the dog incident. So I'm not sure about that, but I think beyond that, we were gonna be ready to move forward.
Ms. Tate?
Yes. So I monitored it. So the only thing that I saw, Beth, was that when she said her eye got blurry, is that the eye just got drier than the other eye. So I'm thinking because it's drier, and when she rubs it to, I guess, moisten it up, it feel like it kind of clears up for her. But the eye does get drier, and that's what I noticed. So I reached out to the ophthalmologist, and he said that he will try to schedule her like a follow-up eye appointment instead of me going to her regular eye doctor at Walmart, to come there at her 6 months, because she just went back in August. So it's not going to be ready till February or March, and he'll just to kind of make sure that the eye doesn't get dry. And then he'll do an extensive review instead of like a regular eye exam, just to ensure that everything's good. He did ask me when did this, because she had the splint fell out, and he'll just double check also to make sure that there's no pieces of the splint in the eye. According to his last notes, there were no piece, the whole splint was out, but he'll double check that as well. But I was just gonna do the plan where Beth showed me the plan where I'm gonna do 10,000 in the court and then 30,000 in the first plan that we talked about.
So it's I guess in the end, it seems like we're ready to go. She was gonna, monitor, make sure there was nothing wrong, but I think sounds like we should be ready to move to
February 21st at 9 a.m. Does that work for everybody for a prove up on this matter?
I mean, I've already made a decision, so I guess what other thing do I have to, what else do y'all need from me?
I
can move it out a little bit further.
I'm asking what all do y'all need from me, because if I've already said what to do with the trust, is it just like the final hearing, or?
Yeah, you need to prove everything up at a final hearing, correct? So I can do February 21st, or I can do, hold on, March 28th.
Okay. Doesn't matter to me. I don't care which one. I mean, I already made a decision, so whichever date y'all want to pick or what's best for everybody else.
My only thing on the 28th, Judge, is I have a deposition at 2:00 that afternoon, but anything before, like in the morning or something, would be.
They're both going to be at 9 a.m. They'll be in the
Okay.
morning at 9 a.m. So
Whatever.
you want the
Should be.
21st? You want February 21st or March 28th?
Sure. I'm good on either, Judge. If we need more time to do things, or so that everything gets set up, then I'm okay with the March one.
Ms. Ronwin?
March is, either one is fine. March is a little bit better for me, but I could.
All right, March 28th, 9 a.m. for a prove up hearing.
All
I
right.
guess I'm so confused. I'm sorry. All right, Beth, can you explain? I don't have counsel. Since we decided on what to do with the 40,000, what happens from here? Because
We're gonna prove everything up. The money will be placed in the registry of the court as far or into some other.
Yeah, I
mechanism.
didn't want it all to go to the registry of the court.
Yeah, I'll arrange that with the defense counsel. We'll get that set up, and he's gonna have a release for you to sign that you can look at.
Okay,
We'll get a final judgment. We'll be prepared for the court to review. And then, and we'll just ask questions, and it'll just be asking some simple questions to you at a hearing, and the judge will hear everything and then just make a decision if it's in the best interest of the child to have the court approve the proposed settlement.
okay.
All right,
Okay.
that concludes the hearing. Y'all have a good one. I'll see you on March 28th with everything taken care of then. Thank you.
Thank you.
Thank you, Judge. Thank you.
All right, can everybody hear me?
Yes, sir.
Yes, Your Honor.
All right. Good morning. We're on the record in 22 CCV 071781, Sandy Ho versus Shanta Nicole Clark and all other occupants. Let me get announcements from the attorneys. Start with plaintiff's counsel. Meyer.
Attorney Christopher Meyer for Sandy Ho, the landlord. We are the appellees, Your Honor. Thank you.
Megan Beasley for Shantae Clark.
All right. We're here on the Rule 51012 motion to dismiss. Mr. Meyer, why don't you get us started with your argument?
Good morning, Your Honor. Thank you. Miss Sandy Ho Wong had hired me to evict a tenant in her house. We went through the entire process at the JP3 in the JP3 courtroom before the Honorable Judge Joyce. We were awarded attorney fees and back rent, and then the tenant filed an appeal. The tenant did not file an answer within 8 days. So I filed a motion to dismiss, and then also the tenant never paid rent into the registry of the court during the appeal. And my client, she was owed over $17,336 in back rent. We had asked for attorney's fees at the JP level, which was $2,000. I'm also asking for another $2,000 for this entire appeal. My client's a senior citizen. She's diabetic with high cholesterol and high blood pressure. She needs the back rent for her own medical bills and her own housing expenses. And, you know, she's taking care of her brother and sister in Hong Kong who are also sick. And it's just, she needs that back rent, Your Honor.
All right, let's talk about procedure real quick. Well, I'll
course.
tell you what, Ms. Beasley, you go ahead and respond, and I want to go through 51012 and the procedure required underneath it. And then again, under 51009 as well, 5109, I should say, regarding the procedure necessary to go ahead and move forward on your motions, Mr. Myers. Go ahead,
Of
Ms.
course.
Beasley.
Yes, Your Honor, not to belabor my written response, but 51012 says if you filed an answer in JP court, that counts as your answer in county court. So that's what we did. Thank you.
That's correct. So it's my understanding, under the transcripts, an answer was filed in the JP court. Is that correct, Mr. Meyer?
There was they did file an answer in the JP court, but when I look at 510.12, it says an answer needs to be filed. And they also received a notice from the JP court to file an answer within 8 days.
I'm going to read you 51012 because to me, I read it. It says that if the defendant has filed a written answer in the justice court, it must be taken to constitute his appearance and answer in the county court and may be amended as in other cases. Thus, the fact that they filed one in the justice court, it must be taken as an answer in the county court, and that constitutes their appearance as well. All right, so your motion to dismiss based on 51012 is denied. Now, with regards to failing to pay into the registry of the court, the monthly amount, you have to look to 510.9. Hold on, let me find that section.
And Your Honor, I'm sorry to interrupt, but if it's helpful, they already got a writ of possession. My client is out.
Oh, well, then that's moot. 1 second, my computer just froze up. All right, well, Mr. Myers, I cannot grant your motion to dismiss and award you attorney's fees. I can, writ of possession was issued, so your client does have possession. If you want to file a motion to retrieve whatever's in the registry of the court at this time, you may do so for back rent.
Okay, all right, understood, Your Honor. We are asking that the judgment at the JP level be affirmed because back rent was already awarded, but we did ask for that decision to be affirmed.
And Your Honor, it has to be a trial de novo, so he can set a trial, but I think that's all that he can do at this point.
Yeah, I don't think I have the authority to affirm it just like that instantly. Tell you what, Mr. Meyer, you file a motion stating the authority and under what code section. Who did I just lose? I lost the other room. Stating the code section of which gives me the authority to just instanter affirm a judgment out of JP court when it's appealed de novo. Then I'll hear your motion at that time. Otherwise, we can't set it for a trial de novo.
Okay, Your Honor, Megan Beasley filed the appeal. This is her appeal, and
Oh.
I'm not. It's her de novo. We're responding as the appellees.
And my apologies. You are correct.
And I'm asking we were already awarded back rent at the JP level, and we would just ask that this appeal be dismissed since no rent was ever paid into the registry of the court.
Your Honor, no rent being paid in the registry allows him to get a writ of possession, which he did. But because we appealed, we can have a trial de novo. And at
I
the
did
trial de
not-
novo, he still has the burden of proof as the plaintiff.
Your Honor, I'm the appellee, and no proof was submitted to me that any rent was paid into the registry of the court. That's why I'm asking this case to be dismissed. I don't see why I would be the plaintiff in the situation. The burden is on the appellee or the appellant to prove that they paid money into the registry of the court.
I'm talking about the burden at.
No, actually, hold on. Oh. 510.9. If the defendant fails to pay the designated amount to the registry of the court within the time limits prescribed by these rules, the plaintiff may file a, which is technically you, Mr. Meyer, would file a sworn motion that the defendant is in default in county court. The plaintiff must notify the defendant of the motion and hearing date. Upon showing that the defendant is in default, the court must issue a writ of possession, which you have. I can't just, I don't know of any authority that just says I can just instantly affirm it once a writ of possession has been issued in this matter. And I just show me the authority if you can.
Okay, Your Honor, in the alternative, I would just like for the appellant's appeal to be dismissed. Because the appellant is not here today. My client's already suffered over $21,000 in damages. She needs a judgment for the amount owed so she can pursue it. And the appellant filed an appeal. The appellant never paid rent into the registry of the court. And now my client's about to be damaged $21,000 on top of the fact that there was over $40,000 of interior damage to the house. And now it appears she's about to be discharged from all of this obligation. I don't see how that's fair.
I get your equity argument, but we also have to follow the statutes. I got to figure out what authority that gives me, where in the statute gives me authority to just dismiss it outright at this point in time. I understand you're arguing that the appellant is not present, but his or her attorney is present, Ms. Beasley.
All right, Your Honor, the authority would be, I would ask that the rent was not paid into the registry of court. On those grounds, I would ask that the appeal be dismissed, or we can move forward and allow them to present their arguments, but I believe we would be wasting the court's time.
Well, if you're gonna 510.9 doesn't give me the authority to dismiss the case, just issue a writ of possession when it's not paid into the registry of the court, the money. Ms. Beasley, do you have any response that you'd like to make to this?
Just the same responses. It looks like Mr. Meyer wants a trial, so he can just set a trial.
All right, let's set it.
Your Honor, today, what is the trial date? January
today-
24th is the trial date today.
Hold on. I don't have note. Let me check the notice that was sent out. The date, let's see.
It's in the Tyler Paul that today is the trial date.
Hold on. So I have your 5-10-12 motion to dismiss has been scheduled for hearing today. And motion for new trial has been scheduled.
That one was sent by mistake and it was retracted. And I did the clerks know not to scan it, but it did get scanned.
Okay, so all that said is the hearing on 5-10-12 motion to dismiss. And I don't have notice otherwise to today's trial date. On top of that, if it was a trial, it'd be in person, not via Zoom. Because I never set bench trials via Zoom. I only set them via in person. All right.
Well, if this is the appellant's, it's their appeal, they would need to request a trial or just dismiss it, because I as the attorney for Sandy Hook,
here's what I'm doing, Mr. Meyer. I'm setting it for trial. And if they want to dismiss it, they can dismiss it. If not, then we're trying this case. It'll be tried on February 22nd at 1:30 p.m. in my courtroom it's set for a civil bench trial.
22 February, 1 p.m.
Yeah, February 22nd, 1:30 p.m.
Thank you.
Thank you, Your Honor.
All right. Y'all are free to go. It concludes the hearing.
Which one is this one on?
They're both dismissed.
Thank you.
Good morning.
Mr. Jones, you're on the Bank of America NA versus William Mallory.
Yes, sir.
That case has been dismissed. They've dismissed
Okay,
the
thank you.
file.
Thank you, Your Honor.
Thank you. You're free to go. Mr.
Okay.
Morris,
Yes,
it's my understanding that your matter has also been dismissed as well. Is that correct, Ms. Toller? The dismissal was filed.
They filed a Rule 11 agreement and it's set for final entry on 2/21.
There we go. Okay.
yes.
So on 2/21, a final entry will be entered on this matter. Final judgment.
Can you turn the volume?
All right. You're free to go at this time. Mr. Morris, can you hear me?
Yes,
Okay. You're free to go at this time. All right. That concludes today's morning docket. Thank y'all.